Are we ready on King?
Ready on King, Your Honor.
All right, I'm ready on King. Let me know when Ms. King is ready.
I didn't hear what the court said, Judge. It went
No,
in and out.
I was telling the courtroom to let me know when Ms. King is ready. I mean,
Oh, okay.
how long we were gonna do what we were doing. Okay, these are case numbers 214446201, People of the State of Michigan versus Marquetta Sakil King. Defendant is charged with 1 count of assault or assault and battery. Defendant also has case number 194430601, and the defendant is charged with another count of assault or assault and battery. Today is the date set for pretrial conference. Appearances, please.
Good morning, Your Honor. Christina Ritter on behalf of the people, P number 83505.
For the record, Your Honor, Janice Stevenson appearing on behalf of Ms. Marquetta King. Ms. King, ma'am, please say your full name.
Please say your full name.
My middle name too?
Yes, ma'am.
Please say your full name. Now, if your full name.
Marquetta Sakil King.
Thank you. Today is the date set for pretrial conference. How are we proceeding?
Your Honor, on behalf of Ms. King, we would move for dismissal for the complainant's failure to appear.
Ms. Ritter?
Judge, it is scheduled, well, both matters are scheduled for a first-time pretrial conference. I do understand that both of these matters are 3 to 4 years old, so I'm asking the court respectfully to adjourn these pretrial conferences and give the complaining witnesses one more opportunity to appear.
Today is the date set for pretrial conference, and the court is going to deny defense counsel's motion for dismissal. I'm going to grant the people's request for a one-time adjournment, giving them an opportunity to locate and notify the complaining witness of the obligation that they appear before the court. I am going to set a final pretrial conference for Thursday, February the 29th, at 8:36. The complaining witness is required to appear. Failure of the witness to appear will most likely result in the matter being dismissed unless the people have a valid explanation as to. That's a lot of noise. Can somebody help me? That's a lot of noise.
The officer just came back in the courtroom. That was just the door.
Okay, well, I'm on the record, so let's be mindful when we're coming in and out of the courtroom that I am on the record. The complaining witness is required to appear. Failure of the complaining witness to appear will most likely result in the matter being dismissed unless the people have a valid explanation as to why the complaining witness could not appear or should not be required to appear. Bond will continue with no contact with either complaining witness. Anything further?
Judge, did I hear the court correct that was the final pretrial schedule?
I didn't hear what you said.
Did I hear the court correctly that there was a final pretrial scheduled on February 29th?
I don't know, but it's adjourned pretrial.
Okay, thank you, Judge. Nothing further.
Nothing further on behalf of Ms. King. Thank you very much, Your Honor.
Then we're all set until February 29th. Have a great day and stay safe.
Thank you, Your Honor.
You're welcome. And it looked like she out of dress code. Let me just tell y'all this. She's literally stood before me in a whole outfit that looks like it's completely out of dress code. So maybe you want to go give your client a copy of the dress code policy.
Okay, I'll do that, Your Honor. May I do that now, Your Honor?
Please, please, Ms. Stevenson, she's leaving. Good morning, Mr. Pearlman.
Good morning, Judge. How are you? I'm here for Donta Hall.
Hold on, Mr. Pearlman. Now, you know that's not how I operate. Good morning, Mr. Pearlman.
Good morning, Judge.
Okay. And yes, I know that you're here for Donta Hall, but your client is not here. So, and
Judge,
you floating in the air. You floating in the air, Mr. Pearlman. So that might not be a good, you on a virtual, but you might have to call your client. They're not here.
Okay, I will call him right now. I am about to start continue a jury trial, Frank Murphy, in a few minutes. So I was hoping to get this. So I'm going to call him right now.
Yeah, call him right now because it's not going to get adjourned. It clearly has a jury trial already or some type of trial on the docket already.
Yeah, so okay, thank you. If I may, as the complaint. Okay.
Call him, Mr. Pearlman. Good morning, Ms. Nelson.
Good morning, Your Honor.
I didn't see your name. Who are you here for?
Brandarian Barker. And he should be in the waiting room.
He is in the breakout room because I didn't see your name, but he's in breakout room number 6. You didn't need to speak with him?
No, Your Honor.
And you're here for him on all, are you aware that he has 4 separate cases?
I am not.
Okay, so you may not be on all the cases. So
I'm happy to take them if I can get discovery, etc.
Okay, because he has which case did you think, which case were you here for?
Yes, 1 second.
Okay.
I am aware of a breaking and entering, illegal entry without owner's permission, and loitering on a private property trespass.
Okay, so that's the case ending in 069. So he also has 2 retail fraud cases and 1 escape from custody case.
Okay.
You are okay. And you do you now want to speak to him or you okay?
Yes.
Okay.
I'll talk to him.
So I'll send you, he's in breakout room number 6. I'll send you to 6.
Thank you.
Mr. Flanagan, send Ms. Nelson the ROAs for those, for the other 4 cases.
Yes, Your Honor.
Where's Ms. Stevenson, please?
She just left the courtroom, Your Honor. She's going back over.
Okay. Ms. Ritter, do you have any hunch about the Michelle L. person?
That might be Miss Lester, who is my complaining witness for Smoot.
For which one?
Smoot.
Okay. I'll let them in a moment. Ms. Smoot, please accept to join the breakout room. Wait for the lawyers to come in to speak with you. All right, I'm ready on McQueen, although his camera is not in the best position. Can you move your face back some from the camera? And that's probably, I don't know. Okay. All right, this is McQueen, case number 234455201. The people of the state of Michigan versus Terrence Ralph McQueen. Defendant is charged with 1 count of assault or assault and battery. Today is the date set for pre-trial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Mr. Terrence McQueen. Mr. McQueen, sir, please say your full name.
Terrence Raphael McQueen.
Thank you, sir. Today is the date set for pre-trial conference. Ms. Stevenson.
On behalf of Mr. McQueen, Your Honor, we would move for dismissal for the complainant's failure to appear.
Ms. Ritter.
So, Your Honor, the complaining witness, Mr. Brian Claiborne, did log in this morning. He looks like he was having some technical difficulties on Zoom. I respectfully ask for an adjourned pretrial conference, have the people reach out to Mr. Claiborne and either have him come in person or get situated so that he can appear on Zoom.
All right, today is the date set for pretrial conference. I did see an individual log in, however, they were not, well, I don't want to say they were not able to, they did not properly connect when brought into the courtroom. The court is going to deny defense counsel's motion for a dismissal. I will grant the people's request for one-time adjournment, continuing a not guilty plea on behalf of Mr. McQueen, giving the people an opportunity to notify the complaining witness of the obligation that they appear before the court and that they may have to come in person if they're not able to connect to Zoom. Court is going to set the matter for February the 29th, 2024 at 8:36. Complaining witness is required to appear. Failure of the witness to appear will most likely result in the matter being dismissed unless the people have a valid explanation as to why the complaining witness could not appear or should not be required to appear. Bond will continue with no contact with complaining witness. Anything further?
No, thank you, Judge.
Nothing on behalf of Mr. McQueen. Thank you, Your Honor.
All right, then, Mr. McQueen, you're all set until February 29th. Have a great day. Stay safe.
You too. Thank you.
Thank you. Ms. Nelson, are you ready? Ms. Nelson? All right. I'm ready on Matthews. This is case number 234557901, the people versus Vanessa Renee Matthews. Defendant is charged with 1 count of operating while intoxicated. Today is the date set for pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Ms. Vanessa Matthews. Ms. Matthews, ma'am, please unmute and say your full name.
Vanessa Renee Matthews.
Today is the date set for pretrial conference. How are we proceeding?
Your Honor, Ms. Matthews and I have had the opportunity to discuss this matter, and she's had the opportunity to review with me an advice of rights form. At this time, it is my understanding that Ms. Matthews wishes to avail herself of an offer from the people, waive her rights instant trial, and offer the court a plea of no contest to one count of the reduced charge of operating while visibly impaired. The basis of the no contest plea, Your Honor, is to avoid civil liability stemming from any statements that might be made today. We would stipulate to the investigator's report for the factual basis.
Ms. Ritter, is that the people's offer?
That is the people's offer, Judge, and we have no objection to a no contest plea.
Ms. Matthews, your lawyer has indicated that you want to accept the people's offer. Is that what you want to do?
Yes.
Ma'am, I'm going to share my screen. On my screen will be an advice of rights form. My question to you is, have you had an opportunity to review for yourself or to go over with your lawyer your constitutional rights?
Yes, I have been able to go over it.
When you did that, did you understand your constitutional rights?
Yes.
Do you understand that this is a misdemeanor and therefore you have a right to a trial? However, if I accept a plea from you today, you will be giving up your right to a trial.
Yes.
Has anyone threatened you in any way or promised you anything that was not placed on the record today to get you to enter into this voluntary plea?
No.
Are you currently on probation or parole?
No.
Finally, drawing your attention to number 11 on the advice of rights form, do you understand that if I accept this voluntary plea, you may be giving up your right to an automatic appeal? And if you were to change your mind about the plea, you would either have to request permission of this court to set aside your guilty plea or request permission of the circuit court to appeal the conviction. Do you understand?
Yes.
With that understanding, do you still want to give up your right to a trial and enter into a voluntary plea today?
Yes.
Ms. Ritter?
Thank you, Your Honor. On June 18, 2023, near M10 Freeway and Forest Avenue, Detroit, Michigan, the complaining witness, Trooper Alexis Brown, has filed a sworn complaint in this court stating that on the date and the location described, the defendant, Vanessa Renee Matthews, contrary to law, did operate a motor vehicle upon M10 Freeway near Forest Street, a highway, while intoxicated, having a blood alcohol level of 0.08 or above, contrary to MCL 257.625, subsection 1.
Ms. Stevenson?
So stipulate for purposes of plea, Your Honor.
Court receiving the stipulation will accept a no contest plea to one count of operating while visibly impaired. Having accepted that no contest plea, the court is going to set sentencing for March the 7th, 2024. Ms. Matthews, you have a right to be sentenced in person. However, you may consent to being sentenced on Zoom. Which do you prefer?
Zoom.
Court sets the matter for 9 o'clock on Zoom. Prior to sentencing, you must submit to a pre-sentence investigation and substance abuse evaluation. Probation is going to contact you by telephone. If they cannot reach you, they will mail you a letter and leave you a message directing you to contact them. Make sure you respond to probation so that I can have a proper pre-sentence investigation on the date of your sentencing, okay?
Okay, thank you.
You're welcome. Anything further with respect to Ms. Matthews?
No, thank you, Judge.
Nothing on behalf of Ms. Matthews. Thank you, Your Honor.
All right, ma'am, you're all set. Have a great day. Stay safe.
Thank you, you too.
Ms. Nelson? Ms. Nelson?
Can you hear me, Your Honor?
I can, yes.
My Zoom keeps freezing. I'm sorry.
Okay. All right, I'm ready on Barker. These are case numbers 204452801. People versus Brendarian Barker. Defendant is charged with retail fraud. Case number 204452701. Mr. Barker, keep yourself muted because you're giving me feedback. until I'm ask you to unmute. 4452701, defendant is charged with escape from custody, and today is the date set for an arraignment on a bench warrant. On that case number 204463801, defendant is charged with retail fraud. Today is also an arraignment on a bench warrant. And case number 234506901, the defendant is charged with breaking and entering without owner's consent and trespass. Today is the date set for an arraignment on a bench warrant. And then I don't know if for the first retail fraud, if I said today is the date set for pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Good morning, Your Honor. Sophia Nelson of Neighborhood Defender Service on behalf of Mr. Barker, P77960. Mr. Barker is present, also via Zoom. Mr. Barker, can you unmute and state your name for the record?
MIBryant Barker.
All right. Mr. Barker, are you able to hear us clearly? Because you don't have a good signal.
Yes, I can hear you guys.
Okay. All right. So Mr. Barker has 4 cases, 2 retail fraud and the escape from custody and the breaking and entering and trespass. They are all, I'm just looking at the registers with respect to the 3 that are set for arraignments on the bench warrants. They all appear still to be plea or pre-conviction matters. So with respect to each matter, well, let's address the 3 arraignment on the bench warrants. With respect to the arraignments on the bench warrants, Ms. Nelson, how do you wish to proceed?
Mr. Barker, as soon as he became aware of these warrants through his probation at Frank Murphy, presented himself in person at 36th District Court to get new dates, and has been complying and appearing accordingly. I would ask those warrants to be set aside.
The court is going to enter not guilty pleas as to the arraignments on the bench warrant. I will set aside any capias, recall any warrant, and we will continue those matters to a pretrial conference. And then with respect to the 1 case, it is scheduled for pretrial conference today, the retail fraud. How do you want to proceed with respect to those?
We would enter a plea of not guilty, Your Honor. I would ask that discovery be tendered in all matters to me so that we can make some informed decisions going forward.
All right, Ms. Ritter, with respect to the 2 retail fraud, is it the same complainant or is it different complainant?
Different corporate complainantship.
Okay, so for the 1 that's scheduled for pretrial today, who's the complaining witness?
I have Mad Anthony Store.
Who?
Mad Anthony Store.
MAD?
Yes.
Okay, MAD. And then what about the other retail fraud?
Ebony Pink Beauty Supply.
Okay. All right, the court is going to I'm going to continue the pretrial conference on each matter. I'm going to set them for I'm going to set them for pretrial conferences on, let's go with March the, well, let me ask a question, Ms. Ritter, because I prefer, because there are 4 cases, and then I am going to require the complaining witnesses on the cases to appear, but I still prefer that Ms. Nelson maybe get the discovery, because especially the escape from custody, there's no complaining witness. So if I set a pretrial conference for March 14th, is that too soon for you to get her to discovery, or?
No, Judge, that's fine with the people.
Okay, so is March 14th a good day for you, Ms.
Yes, Your Honor.
All right, so let's go with March 14th for all of the matters I'm going to set for pretrial conference. And then let's try to get the discovery to Ms. Nelson by March 1st. Is that a weekday? Yes, by March 1st. Also, let's just put them all at at 8:25, even though the first one is already a pretrial, but just put them at 8:25. And then that way I'll know that the complainants on the other cases are should appear. As to bond, did he post a bond to get these, or he probably didn't? Because he just found out about the warrants and then came in.
We did. I believe they were $0 bonds, Your Honor, because I went with him to the front desk.
Okay. Then for each case, bond will continue with no contact with the complaining witnesses. Anything further?
No, thank you, Judge.
No, thank you, Your Honor.
All right, Mr. Barker, you're all set. Have a great day. Stay safe. Ms. Nelson, did you see the okay. Did you see the I cannot gather my thought right now. I know what I'm trying to say. The announcement for Judge Perkins' mom. Did you see that?
I did. I'm very sorry to hear that. Yes.
Yes. Okay. All right.
Thank
All
you.
right. You're welcome. Have a great day. Stay safe.
You too.
All right. Bye-bye. Mr. Perlman, your client is here. Are you able, or did you start your trial? What's going on? Mr. Perlman, are you able?
I'm sorry. Good morning.
That's okay. Are you oh, he's not connected though. Let me see if he connects, but
Thank you.
What are you trying to do? Are you just continuing it to the trial?
Well, I think we scheduled a final pretrial and subpoena the officer, and
that doesn't sound like something I would do, Mr. Perlman. But maybe I said the people should confirm. I don't know. What's the trial date for this?
it is. It's in February. It is.
I'm gonna tell you in a minute. His name? Hall. Mr.
February 8th.
Okay. February 8th. I don't have a trial on.
Oh, maybe it's in.
It could be. No, it could be. My book is not.
I'm sorry. No. It is February 1st.
February 1st. I mean, same thing. I still don't have it. Mr. Flanagan, when is the trial for?
February 1st, bench trial, Your Honor.
See, Mr. Flanagan, you see why we should have went through the thing yesterday? What time do I have it for?
It's a noon check-in.
Okay, so if I don't know why, let's just go ahead. Your client is here. I don't want you to get fussed at by the circuit court. This is case number 224531201. The People versus Donta Jamar Hall. Defendant is charged with guns, reckless use. Today is the date set for final pretrial conference appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people. And Your Honor, I have my OIC in the courtroom. Can he put his appearance on the record, or come as a camera and put his appearance on the record?
Oh, nobody made me aware of that, but okay.
Detective MIBryant.
I don't think my court reporter heard you. Say it a little slower and a little louder.
Detective MIBryant, last name ABBIJANOVIC.
Thank you, Detective. All right, so Mr. Perlman, today is the day. Well, I'm sorry. Today is the day set for strike it. Mr. Perlman, your appearance. I'm moving too fast.
Good morning, Judge. Thank you. Jeff Perlman on behalf of Donta Hall, P80517.
And Mr. Hall, state your name.
Don Hall.
All right, today is the date set for final pretrial conference. So, Ms. Ritter, your OIC is in the courtroom. Are the people going to be ready to proceed to trial?
Judge, I did have an opportunity to speak with my OIC during the preparation of this trial, and the people are not ready to proceed, but the people would like to make a record.
Okay.
Thank you, Your Honor. So, Your Honor, I had a conversation with the OIC on this case to try to locate the necessary witness so that we will be able to continue to the February 1st bench trial. It's my indication from the detective that he did make contact with the necessary witness, Mr. Torrey Kelly. And from my understanding, Judge, the necessary witness did indicate that he did not wish to participate in the prosecution of this matter. So with that being said, Your Honor, the people have no other independent evidence outside of the necessary witness to meet their burden of proof. So we will not be able to proceed to trial on February 1st.
Detective, is that your understanding? You actually made contact with the witness?
Yes, ma'am, that's correct. I spoke with this, who stated that he's out of state and he refused to testify.
Oh, okay. All right, Mr. Perlman.
Judge, on that basis, I would ask the court to respectfully dismiss this matter.
All right, today is the day set for final pretrial conference, and the court is going to grant defense counsel's motion and dismiss the matter without prejudice. As the people are unable to proceed at this time, the witness refuses to return to Michigan to prosecute the case. Mr. Hall, Mr. Perlman will get you a copy of an order of dismissal for your records. Mr. Perlman, I know you're in trial, so at your first opportunity, if you could submit an order to Mr. Flanagan, okay?
Very well. Thank you so much. Have a great day.
All right. You as well.
Bye now.
All right. Mr. Hall, you're all set. Have a great day. Stay safe. Thank you, Detective.
Thank you, Your Honor.
Ms. Lewis isn't connected, so Mr. Owens, I'm going to put you back in. Your lawyer is here, but she's not connected to, she doesn't have sound and she's not on video yet. So I'm going to put you back in the waiting room, but she is here and we'll try to get her connected, okay? All right, then I'm ready on, are we ready on? Oh, I was going to bring in this person to see if this was your witness. You said, did you think this is your witness on which case?
Ms. Smoot, under 9 o'clock.
All right, let me bring the person in. Now this other person, their name sounds familiar, but they're not on the docket today.
Is that Ms. Francillion, Judge?
Yes.
She's a complainant witness for next door.
Oh, well, why is she here? Okay. Michelle L., can you please state your, unmute and state your name for the court?
Michelle Laster.
Thank you, Ms. Ritter. This is your witness.
Turn up my name.
All right, Ms. Francillion, can you unmute and state your name for the court? Ms. Francillion, unmute and state your
Francillion. I'm sorry, John.
Can you?
Marguerite Francillion.
Thank you. All right, ladies, can you please start your video cameras? Ms. Francillion, you're in the wrong place, ma'am. You're supposed to be in Judge Garrett's courtroom at 9:45. You're in courtroom 339. You should be in courtroom 338. Please log off and log into 338 instead of 339, okay? All right. Ms. Lester, I'm going to send you to a breakout room. The prosecutor will come in shortly to speak with you. Please accept to join breakout room number 20, Ms. Lester. And then, there's Ms. Reed. Hold on, let me check. Ms. Reed, are you ready? All right. Okay, I got a lot of people with their cameras off. Y'all know I don't like doing this. Ms. Hall, are we ready on Urquhart?
Yes, good morning, Your Honor.
Good morning. All right. So let's do Urquhart, and then I'll bring in these other two. No, I thought did you all talk to Ms. Moses?
Yes, I believe she may have left and come back.
Miss Reed, I don't know why you should be able to unmute. I don't know why you can't unmute. You should be able to. It's not. Maybe you need to log off and log back on, because it's nothing that I'm doing that's causing you not to be able to unmute. No, I'm not doing anything. Everybody can unmute. Mr. Urquhart, are you unmuted?
Yes, Judge.
I know. Okay. All right. She had to log off and log back on. Okay. This is case number 214532301, the people of the state of Michigan versus Gerald Samuel Urquhart. The defendant is charged with operating with a high BAC, operating while intoxicated, driving while license suspended, revoked, denied. Today is the date set for pretrial conference appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
And for the record, Your Honor, Rakidia Hall, P number 82954 on behalf of Gerald Urquhart. Sir, may you state your full name for the record?
Gerald Urquhart.
And what's your middle name, please, sir?
Samuel.
Thank you. Today is the date set for pretrial conference. Ms. Hall.
Your Honor, Mr. Urquhart would like to continue his not guilty plea and set this matter for a final pretrial, and we would also like to request discovery.
Court is going to continue a not guilty plea on behalf of Mr. Urquhart. Set the matter for final pretrial conference. Court sets a final pretrial conference. Let's go with I'm actually can't do that in the March. All right, let's go with April the 18th at 9 o'clock. Discovery should be submitted by March 19th. Bond will continue with no drinking, no driving without a valid license, and Mr. Urquhart is going to submit to your analysis twice a month as a condition of bond. Probation is going to contact you to set that up if it's not already set up. Anything further?
No, thank you, Judge.
Nothing for Mr. Urquhart.
All right, sir, you're all set until April 18th at 9 o'clock, but make sure that if you haven't heard from probation in about 14 days about that, your analysis, contact your lawyer or my courtroom, okay?
Yes, Judge.
All right, you're all set, sir. Have a great day. Stay safe.
You too.
Thank you. All right, Miss Lewis. I said Miss Lewis because I got a friend. Now that's so funny. Miss Reed, I have a friend named Tatanisha Lewis, and I just called you Miss Lewis for no reason. All right.
Tanisha, is she older? Is she our age?
No, she's a little young. Well, I don't know how old you are. But I'm 57. She's older than, she's younger than me. She's just gonna be turning. She might not want me to tell her. She's not yet in her 50s.
Oh, I'm in my 50s. Okay.
Yeah. So she, and I'm looking at you talking about Miss Lewis. That don't even make sense. I'm gonna tell her. She on my mind. Are you ready?
We are ready, Judge.
All right. That's funny. She must be on my mind. All right, Mr. Owens, I'm ready for you now. You can turn on your camera for me. All right, there we go. Thank you. This is case number 234451201. The people versus Tony Leonard Owens. Defendant is charged with 1 count of brandishing a weapon. Today is the date set for a final pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Good morning, Mayor. Please, His Honorable Court, Katanisha Reed, on behalf of Tony Owens, who is present via Zoom.
And your P number, counsel?
71454.
Thank you, Mr. Owens. Unmute and tell me your full name, sir. Unmute and tell the court your full name.
Tony Leonard Owens.
Thank you, sir. Today is the date set for final pretrial conference. Ms. Reed, how are we proceeding?
Granted, we would like the trial date.
All right, the court continues a not guilty plea on behalf of Mr. Owens and set the matter for trial. Mr. Flanagan?
Yes, Your Honor.
I forgot to ask you to contact, well, no, because it's not even enough days for me and Judge Garrett to have a trial that week. It's because of the title of the games. All right. Never mind. So I just got to skip that week. But let's go to now let me get my old book, because this new book is messing me up. Is it the case that I only have 2 trials scheduled for June 11th?
Yes, Your Honor.
Is it also the case that I only have 2 trials scheduled for July 1st?
Yes, Your Honor.
All right. Miss Reed, I can give you June 11th or July 1st. You would be the third in priority on both those days, but there's a good chance that I think something is going to happen with the 2 cases on July 1st.
I'll take July 1st, Judge.
Okay. The court will set the matter for July 1st. Mr. Flanagan, tell me the final pretrial conference for the Lavelle Baker case that's on July 1st.
Final pretrial June 5th at 9:10 a.m.
And what about Jalen Adams?
Same day, Your Honor, June 5th, 9:10.
Okay. So let Miss Reed, let's
June 5.
No, I want to put you on June 6th. Let's see. Oh no, I can't put you on June 6th. I'm gonna be in Jamaica. June 5.
You deserve it. I just got back from DR on Sunday.
Oh, did you? Oh, wow. You know, the last time I went there, I got caught in a hurricane and had to be evacuated to the dome. But the trip was still amazing.
I just got a place there.
Oh, really?
Yeah, so I go.
Okay, Mr. Owens, you see how Mr. Owens, now
Yes,
why
ma'am.
are we, if you ever had to order this transcript, you're gonna laugh and be like, they were just talking about traveling and things and such. So it is going to be on June 5th, but let me put you at 10:30.
Thank you, Your Honor.
I'll do a final pretrial June 5th. I'll put you at 10:30. That way I'll know for sure what is going to happen with the other 2 cases. Okay?
Thank you, Your Honor.
All right, we're all set. Have a great day. Stay safe.
Thank you, likewise.
All right, bye-bye. Oh, I have to look into that. I'm gonna have to ask her why she got a place there. All right, I'm gonna bring in Okoro. Is that you all's client? Yes. And then we can, Miss Hall, are you ready on Burnett and Moses?
I am ready on Moses. I can get ready on Burnett.
Okay. Here we go. Somebody just went to work. or something. All right, soon as Mr. Okoro connects, there he is. All right, Mr. Okoro, Mr. Okoro, you might have to come to court. You look like you can't hear in order to attend court, and you got a cup in front of you. So I'm going to go ahead and adjourn Mr. Okoro. He might have to come in person because we're having a little difficulty attending Zoom. And then he feels like it's appropriate to just interrupt me in the middle of my sentence. All right, so Zoom court might not be for you. And then I don't understand why you would be losing patience with me. I mean, literally, I don't know why you would be losing patience with me. So here's the thing about attending Zoom court, Mr. Okoro. I have completely lost my patience with individuals who are not coming to Zoom court ready to attend Zoom court. So the reason why I've just said that you may have to come in person is because you were not prepared to come to Zoom court. You don't have headphones, because if you knew that you were going to be in a place that was going to be loud, then you should maybe have to do headphones. I'm not going to look down your eardrum in order to do court. It's not necessary. You saying you can hear me, but you keep putting your ear up to the device. So we're going to give it sir, it's not a back and forth. It's literally not a back and forth. So we're going to give it a try. And if I'm not satisfied, then I'm going to go ahead and schedule it in person. And so that's how that's going to go. So I'm going to send you to a breakout room. Please accept to join the breakout room. The lawyers will be in to speak with you shortly. I'm ready on Moses. This is case number. These are case numbers. Can you find out if her lawyer is going to be still representing her, or is she talking to the MFD? These are case numbers. So I'm sorry, what were you saying?
My apologies, Your Honor. She's talking to MFD.
Okay, these are case numbers 164411701. The People versus Angela Moses. Defendant is charged with 1 count of assault or assault and battery, 1 count of malicious destruction of a building. Also, case number 224488901. Defendant is charged with 1 count of assault or assault and battery. Today is the date set as to both matters for pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Rakidia Hall on behalf of Angela Moses. Ma'am, may you unmute yourself and state your full name for the record?
Angela Moses.
Today is the date set for pretrial conferences. How are we proceeding?
Your Honor, we are requesting a dismissal in the absence of the complainant for both cases. However, if you are not inclined to dismiss this matter, we have no objection to an adjourned pretrial with the complainants required to appear.
Ms. Ritter.
Judge, I don't see either complaining witness in the waiting room. It's scheduled as a first-time pretrial they're scheduled as first-time pretrial conferences on the docket. Judge, respectfully asking the court to adjourn the pretrial conferences and give the complaining witnesses one more opportunity to appear.
Court is going to continue not guilty pleas on both matters as to Ms. Moses, deny the defense counsel's motion for dismissals, grant the people's request for an adjournment, giving them an opportunity to locate and notify the complaining witnesses of the obligation that they appear before the court. I'm going to set the matters for February the 29th at 8:36. The complaining witnesses are required to appear. Failure of the witnesses to appear will most likely result in the matters being dismissed unless the people have a valid explanation as to why the witnesses could not appear or should not be required to appear. The bond will continue with no contact with the complaining witnesses. Anything further with respect to these matters?
No, thank you, Judge.
Nothing further.
All right, Ms. Moses, you're all set. Have a great day. Stay safe. Ms. Ritter, you never went into the breakout room, did you?
No, Judge.
Okay, go now.
Okay, thank you.
All right. Are we ready on Smoot?
Ready on Smoot.
And then are you gonna do Burnett?
Ms. Stevenson will do Burnett.
Okay. This is case number 234496301, the people of the state of Michigan versus Lillian Chanel Smoot. The defendant is charged with one count of assault and battery. Today is the date set for final pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people. I have the complainant witness present via Zoom this morning. Ms. Lester, unmute yourself and state your name for the court, please.
Michelle Laster.
Brikidia Hall on behalf of Lillian Smoot. Ma'am, may you unmute yourself and state your full name for the record?
Lillian Chanel.
Uh-oh, ma'am, unmute yourself again and state your full name.
Lillian Chanel Smoot.
Thank you. Today is the day set for final pretrial conference. Ms. Hall?
Your Honor, Ms. Smoot would like to continue her not guilty plea and set this matter for jury trial.
The court continues a not guilty plea on behalf of Ms. Smoot. I will set the matter for jury trial. June 17th. At 10:30. Mr. Flanagan, help me. Oh, no. I'm not setting it for June 17th. No. That's Mr. Crowley. That's the improper. Okay, I'm gonna set it for July 29th. With the final pretrial conference of June 17th. Final pretrial conference is at 9:10. The jury trial will be at 10:30. There is one other jury trial that has a final pretrial conference in March. So it's a good possibility that this one will become the first in priority. With respect to the final pretrial, Ms. Lester, you're not required to appear. However, you should contact the prosecutor's office to just make sure that the July 29th jury trial date is still a go if you don't appear. Bond will continue with no contact between the complaining witness and the defendant. Anything further?
No, thank you, Judge.
Nothing further, Your Honor.
All right, then we're all set until June 17th at 9:10. Have a great day and stay safe.
Thank you.
You're welcome. All right, tell Ms. Stevenson I'm ready.
I am texting her now.
Good morning, Mr. Hargrave. Please, accept to join the breakout room, and one of the lawyers will be in to speak with you.
Thank you. Good morning to Judge.
Good morning. Miss Hall, go into the breakout room with your colleague and tell her I'm ready now. I'm ready now. Thank you. Ms. Burnett, turn on your camera, please. All right, this is case number 234470001, the people of the state of Michigan versus Antonia Yolanda Burnett. Defendant is charged with 1 count of child abuse, 4th degree. Today is the date set for a final pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Ms. Antonia Burnett. Ms. Burnett, ma'am, please unmute and say your full name.
Antonia Yolanda Burnett.
Thank you, ma'am. Today is the date set for final pretrial conference. How are we proceeding?
Your Honor, Ms. Burnett and I have had the opportunity to discuss this matter, and she's had the opportunity to review an advice of rights form with me. And at this time, it is my understanding that Ms. Burnett wishes to waive her rights incident to trial, Your Honor. She wishes to offer the court a plea of no contest to 1 count of child abuse in the 4th degree. Your Honor, the basis, we would be stipulating to the investigator's report for the factual basis. And the basis of the no contest plea is to avoid having any statements made in these proceedings used against Ms. Burnett in the family court proceedings. There is a pending CPS case. There is an ongoing family court case. And the current plan is for reunification of the family, Your Honor.
Ms. Ritter.
Judge, the people have no objection to a no contest plea.
Ms. Burnett, your lawyer has indicated that you want to enter into a no contest plea today. Is that what you want to do?
Yes.
All right. I am going to share my screen. Whoops. Okay, maybe not. Hold on. All right. There we go. On my screen is going to appear an advice of rights form. My question to you, Ms. Burnett, is have you had an opportunity to review for yourself or to go over with your lawyer your constitutional rights?
Yes.
When you did that, did you understand your constitutional rights?
Yes.
Do you understand that this is a misdemeanor and therefore you have a right to a trial? However, if I accept this voluntary plea from you today, you will be giving up your right to a trial.
Yes.
Has anyone threatened you in any way or promised you anything that was not placed on the record to get you to enter into this voluntary plea today?
No.
Are you currently on probation or parole?
No.
Drawing your attention to number 11 on the advice of rights form, do you understand that by entering into this voluntary plea, you may be giving up your right to an automatic appeal? And if you were to change your mind about the plea, you would either have to request permission of this court to set aside your guilty plea or request permission of the circuit court to appeal the conviction. Do you understand?
Yes.
With that understanding, do you still want to enter into this voluntary plea today?
Yes.
All right. Ms. Ritter.
Thank you, Judge. On May 22nd, 2023, at 15398 San Juan Drive in the city of Detroit, the complaining witness, Detective Tanisha Alexander, has filed a sworn complaint in this court stating that on the date and location described, the defendant, Antonia Burnett, did cause a physical harm to a child, Saraji Richardson, by hitting her in the eye, contrary to MCL 750.136B, subsection 7 through subsection 8.
For the purposes of the plea, is that a stipulation to the factual basis?
We stipulate for purposes of the plea, Your Honor.
Court receives a stipulation and accepts a no contest plea to 1 count of child abuse, 4th degree. Having accepted the plea, the court is going to set the matter for sentencing March 7th at 9:00 a.m. Ms. Burnett, you have a right to be sentenced in person, or you may consent to being sentenced on Zoom. Which do you prefer? You have to unmute.
Zoom is fine.
Okay, the court will set the matter at 9 a.m. on Zoom. Prior to sentencing, I would like a pre-sentence investigation. So the court is going to refer you to probation for a pre-sentence investigation. I have a question with respect to the ongoing case, family court case. You said the goal is reunification, but that means, okay, has she entered into a reunification plan?
Yes, Your Honor. Yes.
Okay, so I want the pre-sentence investigation, and I want it to include the reunification plan.
Okay, thank you, Your Honor.
So that I could see what they have her doing. Currently, she doesn't have, the whole point is reunification, so she does not have custody or physical custody of the child in question right now.
That is correct, Your Honor. And when it's appropriate, I would like to address contact.
It's appropriate.
Thank you, Your Honor. I'm not certain what the current contact condition is, but through that reunification plan, Ms. Burnett does visit with Saraji Wednesdays and Fridays. They have supervised visits at this time, Your Honor. So I would ask for no assaultive contact in order for Ms. Burnett to be able to continue to comply with that plan.
I hope she was right now complying with my order, but what is the contact order currently?
I'm not sure about that, Your Honor.
Mr. Flanagan, do you have it?
Your Honor, no assaultive contact with the complaining witness and can only have supervised visits through the Department of Human Services.
Mm-hmm. All right. So I'm going to continue that order with the following modification in case her plan changes before her sentencing. If the Department of Human Services moves to unsupervised visits during, so we can just remove that only supervised visit part. So if the reunification plan moves to unsupervised visits, that's fine. So the court's contact provision will then just be no assaultive contact. Okay.
Thank you very much, Your Honor.
All right. Anything further?
No, thank you, Judge.
Nothing on behalf of Ms. Burnett. Thank you, Your Honor.
All right, Ms. Burnett, make sure you look out for the probation department's phone call. If they can't reach you, they're going to leave you a message and mail you a letter. But I need you to make sure you connect so that you could get that pre-sentence investigation. So I'll have that reunification plan specifically on the date of your sentencing, okay?
Okay.
All right, have a great day. Stay safe.
Thank you.
You're welcome. I'm ready on Okoro. This is case number 234490701, the People versus Shari Jawan Okoro. Defendant is charged with 1 count of brandishing a weapon. Today is the date set for final pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson, appearing on behalf of Mr. Shari Okoro. Mr. Okoro, sir, please say your full name.
Sorry, Jawan Okoro.
Thank you, sir. Today is the date set for final pretrial conference. Ms. Stevenson?
Thank you, Your Honor. Mr. Okoro continues his jury demand. We have jury trial scheduled for March 19th, Your Honor. I need to confirm that.
I didn't update my book. Okay.
And
so the court continues a not guilty plea on his behalf, but for some reason I still have Brake and McCutcheon in my book. What happened with Brake? Is Brake still on for jury trial that day? Mr. Flanagan, that's to you because Brake is not.
Yes, Your Honor.
And did we give them another final pretrial, or are they a go for March 19th?
No, the final pretrial is March 15th at 9:10 a.m.
That means they're still trying to consider an offer. I'm gonna move them. I'm gonna move them from being in first in priority. All right. What about McCutcheon? What happened with Bianca McCutcheon?
that's still on.
Okay. So that's a go.
Mhm.
All right. So then with respect to Mr. Okoro, I'm going to move his jury trial to being the first in priority on April the 2nd. We're going to move Mr. Okoro to the first in priority, April 2nd. Okoro first. So that moves Darrell Smith to second. That moves Deanna Glover to third. And that moves Kevin Hall to fourth. Mr. Okoro's is a go. Everybody else has to do something else. All right. And then with respect to Mr. Okoro, are the people ready to proceed?
The people are ready to proceed, Judge.
So do we need another final pretrial conference? Well, that's in April. This is January. I'm going to set a final pretrial conference for March the. How many do I have on March 20th, Mr. Flanagan?
Three.
All right. March 20th, final pretrial conference so that the people can confirm they are ready to proceed with their witnesses on April 2nd. Mr. Okoro is the first in priority. Anything further?
No, thank you, Judge.
Nothing on behalf of Mr. Okoro. Thank you, Your Honor.
All right, we're all set until March. What did I just say? I'm sorry.
20th.
Okay, March 20th for final pretrial at 9:10. If the people are ready to proceed, you can let Ms. Ritter strike it. You can let Ms. Stevenson know on that March 19th, and then Mr. Okoro don't have to appear. We could just go to the jury trials.
Okay.
Understood, Judge.
All right, we're all set. Have a great day, sir. Stay safe.
Thank you.
You're welcome. Whoops. Ms. Reeves, please accept to join the breakout room and wait for a lawyer to come in and speak with you.
Okay.
I'm ready on Hargrave. This is case number 22441320, the people versus Carlos Deshawn Hargrave. Defendant is charged with operating while visibly impaired. Today is the date set for review. Ms. Stevenson. Oh, Ms. Hall, I'm sorry.
Rakedia Hall on behalf of Carlos Hargrave. Sir, may you unmute yourself and state your full name for the record?
My name is Carlos Deshawn Hargrave.
All right, good morning, Mr. Hargrave.
Good morning.
How you been? How have you been?
I've been good, just working, surviving.
That's good. That's good. All right, so today is the date set for review. Mr. Hargrave, you've done a great job. It's been a long road for you, but you've done a great job. Mr. Hargrave has completed all of the terms and conditions of his probation, and he is at the halfway mark. Ms. Hall?
Your Honor, we are asking that Mr. Hargrave's probation be closed with improvement and that he be discharged from probation.
Mr. Hargrave, you want to be discharged?
Yeah, I'm ready to stop going. I have to drop and pay that $15.
Oh, Mr. Hargrave.
The bad part, I won't be able to see you no more. But other than that, I'm ready to go.
Okay, Steve, now you just made me feel wonderful. You just made me feel great. Okay. You've done a great job, Mr. Hargrave. You've done a great job.
Thank you.
And, I am going to discharge you from probation with improvement. I'm going to close the matter out, and we owe you some money because it says you've paid your balance in full. Mr. Flanagan, can you pull his probation order and see how much he was originally ordered to pay for the oversight fees?
Yes, Your Honor, $420.
And then this was before the chief wanted us to send everybody to the lab, I think. Mr. Hargrave, have you been testing at 36 District Court or a different lab?
I've been testing at ATS on 6 Mile in Wyoming.
Okay, so Mr. Flanagan, can you double check to make sure I didn't charge him for your analysis fees?
No urinalysis fees, Your Honor.
All right, Mr. Hargrave, we're going to send you a check for $210. You should get that in the next 4 to 6 weeks. If you haven't received it in about 6 weeks, call us, text your lawyer, somebody, let us know that you still haven't gotten it, but you should get it as long as your address is updated in the system. Just give me the numbers to your street address, not the name of the street, just the numbers to the street address.
18839.
Mr. Flanagan, is that what you have?
Yes, Your Honor.
All right, we're going to have them mail you that check for $210. Congratulations. Good luck to you, Mr. Hargrave. I wish you all the best.
Thank you. Appreciate you.
All right, you're welcome. All right. Let me see who this iPhone is. And then you're not ready on Farage, huh?
No, Your Honor.
That they're in person. Okay. Can the person on the iPhone that I just let into the courtroom please unmute and state your name for the court?
Amber Burnley.
Amber Burnley. Okay, thank you, Ms. Burnley. Please accept to join the breakout room. Someone will be in to speak with you shortly.
Okay.
All right, then we're on recess until you all get she didn't even let me finish. She didn't even let me finish my statement. Tell your friend that you trust as an officer of the court. And I said next time, let me finish my sentence.
I'll tell her, Judge. Judge, am I free to go since the rest are refused?
No. Just stay here with us. Where you gotta go? What you doing? We might need you for something.
Are you sure, Judge?
No, go on. Look, bye, Miss Ritter.
Thank you, Judge. Everybody have a good day.
You too.
Thank you.
Well, Mr. Flanagan, while we're waiting, maybe we could just no, I don't feel like it right now.
Okay.
We're just
I'll look through.
We're gonna just take a break. We're gonna take a break. All right.
Okay.
I don't see anybody on the front row. Are we ready on the in-person?
Your Honor, I'm not ready on Miss Jackson yet.
There are two in-persons.
I'm sorry, I have Miss Jackson and okay.
Did we let Ms. Stevenson know who all is in person? We got Jackson and Faraj.
Oh, I'm trying to find Mr. Faraj. Okay. All right. Can I just have a minute for both of those?
Yes. Mario, come up here. Mario, come. Come. Ms. Hall, are you ready on Burnley?
Yes, Your Honor.
All right, this is case number 154. Oh, Courtney, are you there?
Yes, sir, I'm here.
All right, case number 154-540-301, the people versus Amber Ashante Burnley. The defendant is charged with one count of operating while intoxicated with an occupant under the age of 16, and today is the date set for review. Your appearance, please.
Rakidia Hall on behalf of Amber Burnley. Ma'am, may you unmute yourself and state your full name for the record, please?
Amber Ashante Burnley.
Thank you. Today is the date set for review. Ms. Burnley was placed on a 15-month probation. She's done very well so far. Ms. Burnley has almost completed the terms and conditions of her probation. Well, yeah, almost 95% complete. She still has apparently some tickets with 36th District Court. Do we know what her balance is on those, Mr. Flanagan? They didn't put it in this review. Is it enough for her to have to get on a payment plan?
I would have to look her name up. 1 second, Your Honor.
Okay.
Yeah, Your Honor, she has one ticket. 1, 2, 3, 4. You want the total amounts?
Are they, well, let me hear from Ms. Hall. Ms. Hall?
Your Honor, it appears that I'm not sure whether Ms. Burnley was aware of the tickets. However, she has been working very diligently and actually overachieving in her probation, given that she's been testing once a week and only supposed to be testing once a month.
Oh, really?
Yes.
Why would they keep letting you test once a week?
I don't know, just taking my money.
Just taking your money. Just taking your money, Miss Burnley. Where are you testing at the court or somewhere else?
No ATS.
Oh, they've been taking your money, Miss Burnley. I can't even give it back to you. All right, Miss Hall.
So, well, now she knows that she has the $90 left to pay for the reinstatement fees for the tickets, which she says that she can pay today. Ms. Burnley, how long would you need to get on a payment plan to pay off your traffic tickets?
Well, let me say this. If I confirm that she's been testing once a week at another agency, I'm going to waive that. Now, waiving doesn't mean it doesn't exist. So what I'm saying is I'm going to waive that condition. Hold on. Hello.
Hey, we got the lease agreement, right?
I mean, it was some. I'm saying I won't require you to have them paid in order to get off probation, but you should know that they're out there. So what receipts, do you have the receipt that show that you were testing once a week?
No, because I would pay in cash. They wouldn't give receipts.
But were the results can you call Miss Tucker, ask Miss Tucker, was she getting results from Miss Burnley on a weekly basis? They still should have been sending it to the probation department.
That's correct. In the report, Ms. Tucker indicated that the testing was reduced at the last review on November 2nd, 2000.
Once a month.
But
yes.
That's what it was reduced to. But it said, however, defendant continues to test.
Oh, you right. I didn't even fit. Now I'm the main one that say reading is fundamental. And I didn't finish the sentence. You are correct. Why would she let you keep testing once a week? She should have told them to stop. Okay. Nonetheless. So Ms. Burnley, you've done a phenomenal job. Let me just count. This is, yeah, you're beyond the halfway point. for the 15 months. So I'm going to go ahead and discharge you from probation. I can't refund the weekly testing because it's not it's an outside agency. But
Okay.
I will go ahead and discharge you from probation with improvement. But you do have a balance at 36 District Court. Are any of them in warrant status, or are they all just payable, like her payables? Or does she have some warrants?
No warrants, Your Honor. They're all payable.
All right, so you got to pay your reinstatement fee with the Secretary of State, and they may not let you if you have this outstanding balance. So they've changed a lot of the traffic laws. I haven't been on a traffic docket in a long time, so I'm not all the way sure of what the Secretary of State will allow you to do to have outstanding in order to get your license reinstated. But as far as this particular case is concerned, you're going to be all set. We'll have Ms. Tucker close you out with improvement, okay?
Thank you so much.
You're so welcome. You have a great day and stay safe, okay?
You too. Thank you.
Thank you, Your Honor.
Bye.
Bye. Are you ready on anything else, or are the rest of y'all be going up? Y'all turn off these cameras so fast. I mean, I guess that's supposed to be what that means, but I guess Zoom, y'all just turn them off so fast. That answered my question. Go ahead on to turn your camera off, Ms. Hall. I sent a message to you through your friend. She gonna tell you what I said earlier when I was trying to talk to you and you had already went to the breakout room. I said they just move about the Zoom so quickly. All right. Let's see. Oh, we're gonna get to that one later because they haven't done anything. Who else do I have in person? Bernie. Ms. Stevenson, I guess you didn't reach any of your clients for this afternoon.
Judge, I'm sorry. To be perfectly honest, I didn't even try once I started looking at them.
Jackson. Okay, wait a minute. Reeves. Oh,
you want me to keep trying, Judge?
Oh, well, I mean, at this point, it's only 10:30, but you can. But if we got to come back at 1:30 for any one of them, we might as well come back for all four of them.
Okay.
All right, I'm ready on Jackson. This is case number 194503201, the people of the state of Michigan versus Angela Ariel Jackson. Defendant is charged with 1 count of child abuse, 4th degree. Today is the date set for review. Ms. Stevenson.
Janice Stevenson, appearing on behalf of Angela Jackson. Ms. Jackson, ma'am, please tell the judge your full name.
Angela Ariel Jackson.
Today is the day set for review, but this doesn't sound like a sentence that I would have given. All right, Mr. Flanagan.
Yes, Your Honor.
Can I see the original probation order? Because they're saying that on a child abuse 4th degree, I gave Ms. Jackson 3 conditions. One being anger management, so that must mean that the child was not hers. This sentence doesn't seem right to me. And they're acting like, and this seems to suggest that she didn't have to start testing until December. Let me see the original order. But meanwhile, Ms. Stevenson, because this doesn't make sense to me, this review.
So, Your Honor, this is our first representation of Ms. Jackson. She was represented by Attorney Louis L. at the time the plea was taken on October 19th, 2023. Ms.
Well,
Jackson,
that can't be. You said the plea was taken October 19th?
sentencing was October 19th, 2023, if I'm reading this correctly.
Okay, well then this here thing is completely wrong. This review that I received is completely wrong. Hold on. Oh, they put the wrong date. What? That is the wrong date. Okay. Okay. So she was sentenced on October 19th. I'm sorry, October 17th.
19th.
19th. And she was supposed to start testing November. So there's nothing in here about why she didn't test in November. And she was going to attend 24 weeks of anger management. Okay, and then I'm looking because since the complaining witness has a guardian, I'm assuming then that it was not her child. Okay. All right, Ms. Stevenson.
And Your Honor, Ms. Jackson advised me this morning that she would like to have the opportunity to do some community service in lieu of as much of the costs and fines as possible. But she says that she did provide proof of completing some anger management to the probation department. So my request would be to continue the probation. I would ask still that she be able to try to get to the halfway point, which would take her to the end of October for a possible early discharge. Otherwise, that the probation continue as scheduled.
What you just said didn't seem to make sense to me. You said you would something that would take her to the end of October. I don't understand.
I didn't mean to say that. I meant to say the end of April.
Well, let me tell you why I'm not going to give her to the end of April.
Okay.
Are there even 24 weeks between now and the end of April? How many weeks are between now and the end of April?
Well, she's saying that she did.
Well, not without proof though, Ms. Stevenson. I'm not going to waste my time without proof putting her at the end of April because, I mean, who did she submit it to?
To her probation officer, Your Honor.
Did she? Because she has a new probation officer. But let's go ahead and call the probation officer then.
Okay.
Now this report from Ms. Bryson was submitted to me yesterday at 2:41 p.m. But if your client is saying she submitted some proof before yesterday at 2:41 p.m., then let's call Ms. Bryson and see why it's not in the report. Mr. Flanagan, can you call Ms. Bryson?
Yes, Your Honor.
Because I'm not going to give your client a date before 25 weeks.
Okay.
If I don't have proof that she's done any anger management.
Understood, Your Honor.
All right, while we're waiting on Ms. Bryson, are you ready on Reeves? Well, let me look at Reeves as between the two of them, neither one of them has done anything. So which one do you want to do first?
Mr. Faraj, Your Honor.
All right, Ms. Jackson, please have a seat at defense counsel's table in the chair. Hold, y'all don't be listening to me. Okay, I don't understand why she's talking. I don't understand that. I don't understand why we would be doing that, but let me be clear, we're in court. And we're not going to be disruptive to court. We're not going to be. Now, if she needs to step in the hall to speak to Ms. Stevenson or whoever that was doing that murmuring and talking, if they need to step in the hall to speak with their lawyer, then let's do that. Okay, come on up to the podium, Mr. Faraj.
Good morning, Your Honor.
Good morning. This is case number 214569301, the People versus Yusuf Adnan Faraj. Defendant is charged with 1 count of gambling, disassociated person. Today is the date set for review. Appearances, please.
Janice Stevenson appearing on behalf of Mr. Yusuf Faraj. Mr. Faraj, sir, please tell the judge your full name.
Yusuf A. Faraj.
I'm sorry, give me 1 second. We did Burnley, right?
Yes.
I didn't write her name down. Okay. All right. Today is the day set for review. Mr. Faraj has not done anything. He was placed on probation for 6 months back in October. This is his halfway point. He needs to be continued to the final review, and he needs to get something done. I don't understand this, but okay.
That's our request, Your Honor.
I apologize. Where did the defendant that was just sitting at the table go?
You said if she needed to talk to the attorney, so I guess she decided to wait for Ms. Stevenson to finish.
That's like inappropriate. Okay, so next time, let's say she's gonna wait at the table that I told her to wait at, and then if she wants to speak to her lawyer, then somebody's gonna say, Your Honor, she wants to speak to her lawyer, then Ms. Stevenson is gonna go out. So can you please go check the hall for Ms. Jackson, please?
Doing it now.
Okay, Ms. Stevenson.
We are going to ask that the court continue the probation to the review date, Your Honor, of April 17th, 2024.
Here's the problem. Here's the problem. He's supposed to attend Gamblers Anonymous twice a month. And if he hasn't started with the Gamblers Anonymous, so one should assume that if I said attend twice a month, I wanted him to at least have, for the probation is for 6 months. He's eligible for discharge after the halfway point. However, one should assume that I want him to have 24 sessions of Gamblers Anonymous. Don't assume that I only want him to have 12. So he's off to a late start, which means he has the possibility of getting his probation extended beyond that 6 months. So he's done nothing.
Mr. Faraj, hold on just a moment, sir. Just 1 second, sir.
Ms. Stevenson.
Thank you, Your Honor. So I would advise the court. I have been in quite regular contact with Mr. Faraj, and he stays in contact with his probation officer as well. He's in a situation similar to some of my other clients about that Gamblers Anonymous, Your Honor, without not being able to get proof of it. So Ms. Lurse gave me.
He can get proof of it.
Well, Ms. Lurse gave me the sign-in sheet after our last hearing. There's a phone number on there for Gamblers Anonymous that they're referring clients to. I gave Mr. Faraj that phone number about 20 minutes ago. So if he has to go in person or whatever he has to do other than taking a picture of himself in the meetings, he's going to do that so that he can get proof of going to Gamblers Anonymous and get that to Mr. Hunter. Mr. Faraj has been struggling, Your Honor, but he's actually getting things righted. Today marks his first week of being employed at a new job, which has given him the ability to take care of issues that were interfering with his transportation. He's gotten his license and his insurance together. He's back working. He stays in contact with Mr. Hunter. He stays in contact
Does
with,
he? Does he? Because
yes.
here's my question. So when he was in contact with Mr. Hunter, he told Mr. Hunter, I've been attending Gamblers Anonymous, but I don't have proof.
Did you tell him that, Mr. Faraj?
I told them I went to a couple of meetings and they don't allow signing sheets as a private meeting. They didn't feel comfortable.
So I'm going to have a meeting with probation. And I suppose I'm going to say it on the record. Nobody's going to attend a place that is going to say the meeting is private, so I can't even give you proof that you were here. That's crazy. You understand what I'm saying? I'm attending the anonymous thing. If I want proof that I was here, I've never heard in my 30-something years of practicing law where someone is saying, I can't give you proof that you were in a place that's like saying a person goes into a private treatment facility, and then the treatment facility says, well, it's private, so I can't give you proof that you were here. That doesn't make any sense. And once the defendant hears that, oh, they can't give me proof, then stop going. Because that's like me going down to DTE, paying my gas bill, and then the person say, I can't give you proof that you paid it. Well, I gotta have proof that I paid it. No, I have to have proof. Otherwise, you could turn my lights off. You could turn my gas off. I need probation to be more proactive. If he said that to Mr. Hunter should have immediately told him, don't go back there.
He did.
All right, so when I said he hasn't done it, he didn't do it. It has to be something that can be proven.
So, Mr. Faraj, hold on just a second, please, sir. So, Your Honor, Mr. Faraj and I have had this conversation about what's going on with the Gamblers Anonymous. We do believe that there is a path to remedying that situation. He knows he's ordered to go to Gamblers Anonymous. He's absolutely 100% interested in fully complying with this court order and making any adjustments that he has to make in order for him to do that. So we would ask the court, Mr. Hunter, I believe, is here today. Mr. Faraj is in the building today. I've advised Mr. Faraj that he make contact with Mr. Hunter again today. And I think that Mr. Faraj is doing what he needs to do to make sure that he complies with this court order. I would also say I believe that having no contact with the casinos was one of the orders of this court. And if nothing else, Mr. Faraj has complied with that condition, Your Honor. So he's not trying to run from this. He's not trying to show any semblance of disregard for this court's order or disrespect to the court. He wants to do what he's ordered to do, and I believe he's working toward that. And I'd ask the court to give him the opportunity to continue to do so.
Well, I don't think he was trying to be disrespectful or whatever to the court, but I don't think he understands, because he keeps trying to explain that to me. And that's what he keeps trying to explain to me, that he went to a place that he doesn't have proof of going. And so I don't know that he understands that that doesn't count. And so all I'm saying is the first time that I go to a place that's court ordered, I've never had a problem with people who are ordered to AA coming back saying they won't give me proof that I've been in AA. I've never had it. So all of a sudden, wherever the people are going for Gamblers Anonymous, then they better only go where the court sends them, because it's not private. Let me be clear. The court-ordered Gamblers Anonymous is not private. It is not private. It is court-ordered. It's court-ordered. So he has to go to the place that he can have proof of attending. But also he was supposed to attend 12 sessions of gamblers counseling.
So if I could speak to that, Your Honor, that Mr. Farage has not had the money to pay for until he started working last Thursday. And so now he's employed. He's been in touch with Mr. Alexander, who's going to do the gamblers counseling. He knows how much it costs. He has the appointment to get started on that. He hasn't just kind of pushed that off to the side, not doing anything about it. He's done everything that he could do short of starting, and he hasn't been able to start because he hasn't had the money. Now that's rectified. He is ready to get that and able to get that taken care of as well. He has that all set in place to get started, Your Honor.
All right. I guess, need to talk to probation about that because I'm almost certain that the state offers free gamblers counseling. I'm almost certain that the state offers free gamblers counseling. There's a whole 1-800-GAMBLERS thing. The state, there is a whole network out there trying to help people stop gambling. So I don't know why we're not directing people to the right place, but we're going to start directing people to the right place so that they can, if they are able to get off probation either early or at least at the original time. So I don't know, but all right. So he was placed on for 6 months. I guess the good news is that even if he has to extend beyond the 6 months, as long as it doesn't extend beyond 12 months, he would still be eligible for the delayed sentence. So Mr. Flanagan, is he on the docket for the 6-month date?
Yes, Your Honor, April 17th at 10 a.m.
And let me see if that's still a good day for me, April 17th. Yes, it is. All right, April 17th at 10 a.m. So, Mr. Farage, I'm not saying you didn't try, but what I'm saying is I have to have proof. So you got to go to the place that I guess that's on the sheet of paper.
Yes, ma'am.
All right. Anything further?
Just to clarify that, Your Honor, there's an 800 number on the sheet. It's not a location that's listed. So Mr. Farage intends to call that 800 number, but he'll go down and see Mr. Hunter now and just get that finalized.
Okay. And then I'm going to talk to Mr. Farmer because we have to have proof of the Gamblers Anonymous. It just doesn't even, they have to send them to a place that's going to give them proof of the Gamblers Anonymous. All right. You're all set until April the 17th, Mr. Farage.
Thank you, Your Honor.
Can I say one thing if you don't mind?
Yes, sir. Go ahead.
There is proof if you pay $100 a session on Gamblers Anonymous online, there is proof that I can get that way. Would you like me to start doing that?
No, that's a scam. That ain't proof. That's a scam. Don't do that.
There's everything online. Everything online is you have to pay for.
No, that's a scam, and you should report them to the State Gaming Commission Board. That's a scam. That's a scam. You don't have to pay $100 to get proof of Gamblers Anonymous. That's a scam, and don't ever go back there. But you should report them. You should get that information to probation. They should be reported. That's a scam. Okay.
Thank you.
You're welcome. Gamblers Anonymous is free. It's free. It's always free. It's free. Don't pay anybody for Gamblers Anonymous. All right.
Thank you.
Thank you, Your Honor.
Yeah, you're good to go. Thank you. Thank you, Ms. Jackson.
I think you got to talk to Ms. Jackson.
Okay. Thank you, Your Honor.
Okay.
Your Honor, Ms. Bryson is in the courtroom for Jackson.
Okay. Ms. Stevenson is going to talk to her client if she's still here.
Good morning, Your Honor.
I was muted. Mr. Flanagan, do you know who this Fisher person is in the waiting room?
No, let me look up the name. I just noticed them.
All right.
They're not in JIS.
Okay. All right, thanks. All right, are we ready? Ms. Stevenson, are we ready?
Ready, Your Honor.
All right, we're back on the record with case number 194503201, Angela Jackson. Okay, so what? I'm sorry, I didn't write down the issue. The issue is about the anger management.
I think so, Your Honor.
Okay, so good morning, Ms. Bryson.
Good morning, Your Honor.
All right, so Ms. Jackson says that she submitted to you proof that she has done some of the anger management.
I don't have any proof in writing from Ms. Jackson that she completed any increment.
Ms. Stevenson?
So, Your Honor, I just spoke with the receptionist, and through the receptionist, Ms. Jackson's counselor over at Motor City Center for Hope.
What's that? What's that? Because my order says anger management through eBay. What's Motor City Centers for Hope?
Which is the therapist that Ms. Jackson has been working with. It's not eBay, Your Honor. And I have asked that agency to forward whatever proof they have of counseling to Mr. Farmer, and because I didn't have Ms. Bryson's email address.
Let me interrupt you. I don't even know how to say I'm not interested in that.
Yes, Your Honor.
Except to say that I'm not interested in that. I'm literally looking at her probation order. And it specifically says, shall attend 24 weeks of anger management through eBay. And so unless this court has given her permission to do anger management through another agency, unless probation has requested from me to send her to an alternate site, I'm literally not interested in what she has done at a place that the court didn't send her to. That's equivalent to the people who go and do their community service at their own agency, Ms. Stevenson. It's not acceptable, and I don't want those notes. I don't want them.
Okay.
Now, if she wants to talk to her probation officer, this is what they're there for. They're probation officers. They're overseeing the probation. If she wants to talk with her probation officer, who she is supposed to be meeting with on a monthly basis, and if she wants to get permission to go to a different place, which that permission then has to come from me, because probation has no authority. Let me be clear in my words. Probation has no authority to change my order. If I said through eBay, I meant through eBay. And so if we're going to venture away from eBay, then we're going to get permission from me to venture away from eBay. But what we're not going to do is have me give an order and then everybody go out and just do whatever they want to do. There's no need for me. There would be no need for me. And the state should stop paying us. If the people are going to do what they want to do, then there's no need for the judge. There's no need for me to impose the sentence. Probation could impose the sentence. They could say, go to probation for your sentencing. But that's not how it works. So I'm not interested. I'm not interested. I'm not interested in those notes. I'm not. My order is clear. It's not ambivalent. It's clear. It says, shall attend 24 weeks of anger management through eBay. There was a reason I said through eBay. The fact that she has 24 weeks tells me I meant to say through eBay. So no, I'm not accepting that. It's through eBay.
Understood, Your Honor. And I would just say for the record, again, our office did not work with Ms. Jackson at the inception of this case. We did not work with Ms. Jackson when the sentence was handed down. Had that been the case, we absolutely would have been proactive in making sure that she did get into EVA even before she made it over to probation, Your Honor, if that was the order of the court. So I offered the counseling that Ms. Jackson has completed, just so that this court can know that that she's done something. We do understand it's not in satisfaction of the court order, but that she has done something to improve her own mental health, Your Honor, and her emotional health, so that whatever it is that caused the situation to come about is not repeated. I can have another conversation with Ms. Jackson to reiterate the court's order so that she understands it. I know that Ms. Jackson has been experiencing a financial hardship. And so we were asking the court if, in lieu of some of the costs and fines, she could do community service to work some of that off. That's probably also going to cause her a problem with paying for eBay. So I would ask the court to give Ms. Jackson an opportunity to work with Ms. Bryson, and just find out if there is a possibility that the therapy that she has been receiving could
No,
at some point be
no,
considered acceptable.
no, it's not acceptable. Let me tell you why. I've been in therapy ever since my sister died, and occasionally we talk about anger. That doesn't qualify. It absolutely doesn't qualify. Mr. Rice is going to spend a whole hour with the person for 24 weeks, giving them scenarios, tools, and all of that. And the only thing they're going to talk about is anger. The only thing they're going to talk about is how you could work this situation out in different ways. She needs anger management, not counseling. I didn't tell her she needed counseling. Now she may need counseling, but she needs anger management. Also, I'm not opposed to the other place that you all told me about. But again, that is my secondary place. And every person that I send there is going to go through an ability to pay hearing. And they're going to have to produce their pay stub, their tax returns. And they're going to have to prove to me that they don't have an ability to pay that little $20 that Mr. Rice is charging. So if we're going to start sending people to the other place, we're going to do ability to pay, because Mr. Rice's program is phenomenal. It's phenomenal and it's necessary. And I'm not going to start making the other place my go-to. I'm not. Mr. Rice is still my go-to. He is still my go-to. And so for the purposes of probation, if a person is requesting to veer from Mr. Rice's program to go to the other program, we're going to do an ability to pay. Unless the reason is that Mr. Rice is booked up, because I keep sending everybody to him. And again, for the record, I don't know Mr. Rice. I don't know him. I never met him, except on this here Zoom that one time, because the people were so raving about him. So just again, for the record, nobody has to think I know him. I don't know him. I just know the defendants come here and rave about how much he has changed their lives. And therefore, I like his program.
And I share the court's enthusiasm. I'm a big fan of Mr. Rice. I would just I would say that part of and I hear the court about the need to focus on anger management. I do believe, I don't know if she's having separate anger management sessions or what, and if not, then it doesn't work. But with regard to behavior modification, I think the court had an opportunity to watch Ms. Jackson the first time she went up there. And after she and I came out, we had a conversation, and I told her this is going to be an opportunity for you to use whatever your counselor is teaching you with regard to anger management. And she put whatever it was that she's learning into practice, just to adjust her behavior today. So I hear the court about Mr. Rice. I'm a huge fan of Mr. Rice. I just want the court to know it looks like whatever Ms. Jackson is doing with Ms. Kendall is working for her too.
Well, Ms.
So
Kendall is not on my list. So
yeah, sure. Well,
Miss Bryson, yes.
Yes, Your Honor, on behalf of probation, we only refer people to eBay, Redeem, and Care for anger management. So that is not a place that we would have referred her to.
Yeah, and again, and I'm not going to give probation extra work to try to certify a location. We have 3 places apparently that's already certified, and the one that this judge uses is eBay. So I don't even want my people being referred to Redeem or the other place without my approval. The place that I am sending people to is eBay. Now, some of the other people who don't have 24 weeks, because if she got 24 weeks, it says to me that I sent her to eBay because I wanted her to experience Mr. Rice.
Understood. I agree, Your Honor. I agree. Like I said, if we were on it, she would already have been, even before sentencing, hooked up with Mr. Rice. So
okay, well, let's do this. So, of course, your request regarding the community service is a yes. The court will convert all but $210 of the fines, costs, and fees to community service. So that means she still has a balance of $210, excuse me. I will convert, $790 to 79 hours of community service. And then, let's be clear, I have not ordered any individual counseling. I have ordered 24 weeks of anger management. Understood, at a place Judge. Approved by probation. If Ms. Bryson talks to Ms. Jackson and talks to Ms. Jackson's therapist or counselor, and Ms. Bryson wants to request a what do you call it?
Deviation.
A deviation from the court's order, then I will consider it. So I would need to know what about the therapy that she received would cause me to do a deviation. However, in doing the deviation, let me tell you that I'm still, so let's say she's done, I don't know, let's say she's done 10 weeks on, and Ms. Bryson thinks, yeah, it sounds like she's done, because listen to what the deviation should be. Mr. Rice's sessions are 1-hour sessions regarding anger management. You can't equate, if I go to my therapist for 1 hour, and of the 1 hour, we spend 10 minutes talking about anger, that is not equivalent to Mr. Rice's 1-hour session. It's not. So it would have to be, we talked about anger for 1 hour in this particular session. And so how many times did we spend an hour talking about anger? And then you could talk about anger all day. This is how I also feel about it. And you can go to the counselor and talk for an hour and the counselor shake their head the whole time. Yeah. And how did you feel about that? And how did that make you feel? And what did, because the counselor is trying to get you to be aware of your own feelings. And then occasionally at the end, they send you some tools. They might give you some tools. Well, next time when you face that, maybe you could try this. Or why don't you write a letter to those people who have hurt you? And, even if you don't give them the letter, and why don't you, because I was studying psychology too. I don't know. That's how counseling goes. Anger management, you know, they be up in your face and stuff sometimes. They give you tools. Well, how could you have done that situation better? Well, this, that, and the other. So that's why there's a difference. There's a difference between anger management and where we send the domestic violence people, because there's a difference. You don't send a batterer to anger management. You send a batterer to batterers counseling, because they address different things. So, Ms. Bryson, I am giving you some, you know, latitude to request a deviation from me, but that's like kind of what I'm looking at. You know, not the fact that she went to an hour session, but of the hour session, how much of the session was spent on anger management. That's what's important. She was placed on 12-month delayed. Also, Ms. Bryson, you put the wrong date. She was found guilty in September, but she wasn't sentenced until October. So she actually didn't get on probation until October. It doesn't look like she tested in November. And I said she had to test for 3 times before I would discontinue her testing. So she has another test, because it doesn't look like she tested in November. She only tested in December and January. So she has another test. If she tests negative for all prohibited substances at her next test, then her testing can be discontinued. Additionally, if we determine that she has an inability to pay for the anger management, then we can also send her to one of the other approved places by the court, because I think you all said one of them is, you know, free or lower than Mr. Rice's. I know it might just lower than Mr. Rice's, but then we can look at that. Okay.
Yes, ma'am.
All right. When are we going to bring her back? Let's bring her back halfway through the 24 weeks, and then I'll see if Ms. Bryson has submitted for a deviation.
Okay.
So today is January. Today is Thursday, yes. Okay, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. April 18th would be 12 weeks. So maybe we could come April 25th. I don't know how many sessions you think she's done with that therapist, but let's come back April 25th at 1:30. And we'll see if Ms. Bryson has submitted for a deviation for her, okay? And then she now, no problem. She now needs to be referred also to Ms. Green for the 79 hours of community service. Okay?
Yes, Your Honor, I'll take her down to probation and get her started with that.
Okay, then we're all set. Have a great day. Stay safe.
Okay,
Thank you, Your Honor.
All right. All right, this is case number 214489701, the People versus Angelique LaShawn Reeves. Defendant is charged with operating while visibly impaired. Today's the date set for review. Ms. Stevenson.
Janice Stevenson on behalf of Angelique Reeves. Ms. Reeves, ma'am, please say your full name.
Angelique Reeves.
Your full name.
Angelique LaShawn Reeves.
Today is a day set for review. Not only has Ms. Reeves not done anything, she's tested positive for alcohol. The court is going to increase her testing. She's coming in person next time, and she needs to get on track or she's going to jail. Anything further, Ms. Stevenson?
Nothing at all. Thank you very much, Your Honor.
So let's give her a review date for Thursday, March 7th at 10:02. That's in person at 36 District Court. Court is increasing her testing to once a week. If you have any positive tests, you're going to go to sobriety court, and/or court is going to revoke your probation.
I'm not able to make it down there once a week. Out of the whole 6 months, this is the first time I did it. It was on Christmas. I understand the consequences, but it's not like I'm walking around drinking.
Okay.
I haven't did the test. I haven't did the 2 classes because I'm on the eviction payment plan. I got to pay $300 extra on the $900 that I got to pay a month. And I'm trying to fight and get my daughter back. She can't even stay with me during the week because I'm unable to provide for her right now. It's not, I know this is serious. It's not that I'm just putting it on the back burner. I'm not trying to cry to get no sympathy or nothing like that. I know exactly how you are. I'm not trying to make no excuses. Life been lifing, and I haven't been able to deal with this right now because I've been trying to figure out other stuff for me and my daughter, or I'm gonna be on the streets. It's like pay the probation. It's like handle this or be on the streets. I don't got nowhere to go right now. I don't got nothing right now. I start Providence Hospital on January 30th. I found a ride to get to there. I'm gonna be working night shifts in order to try to get my daughter in the morning so I could get her to school and back. I stay in Detroit. My daughter stayed with her dad in Rumlis. It's like a 25-minute drive. I can't drive. I don't have a license, and I have my DUI case. I'm trying so hard. This case was 3-4 years ago. I'm about to be 28 in March. I understand exactly what I did. I have not got arrested, put over, nothing of that sort since then. I understand it was literally just a spur of the moment. I had to drive us home. I understand I could have killed somebody, hit somebody, everything. I understand everything I got going on. But I know y'all hear this a lot, and y'all hear people. And I know life is for everybody, and everybody got stuff that they got going on. But I just want you to understand I'm not taking this as a joke. I did drink on Christmas. I know I should have not. And I had my drop on the 27th. And I can own up to that. But I don't want to set myself up to go to jail because I know for a fact I cannot get down there every week. My probation officer told me she preferred I come in today. I couldn't even get down there today. My mental is all messed up right now. I got all this going on. I'm really trying. I just want you to understand I'm trying. I don't know what else to do.
All right. Ms. Reeves, I hear you. I hear you. I hear you. I hear you. I don't want to say that I'm not moved by it. I don't want to say that. I want to be moved by it. But here's the thing. So, I'm going to give you a chance. I'm going to write on your paper. So let me just tell you what I'm going to do. Just tell you how how my brain functions, right? Because when I was a new judge, I used to get all caught up with the people and be like, oh, they really sorry and this, that, and the other. And then, and then I found out that they don't. However, because of the person I am, I'm not going to lump everybody together. Some people cry, they mean it. Some people cry because they could probably make it big in Hollywood, right? Okay. We don't know which one you are until the rubber meets the road after you cry. It sounds like you have a lot going on. It does. It sounds like you have a lot going on. And I don't know what I would do if I had all that going on that you just told me. But here's the thing about it. It's gonna be going on. And so you have got to figure it out. You do. And that's hard. You got to figure it out. And it sounds like, so let me just say this, based upon what you said, it sounds like you're trying to figure it out. And you may even think you're doing the best you can, but I'm gonna just tell you this, and then I'm gonna give you another chance. I'm gonna give you another chance. So you don't have to worry about it right now. I am going to give you another chance. But some days when life is lifing, I really love that little thing that they came up with in the last however many years. But when life is lifing and I be like, I'm doing the best I can. Sometimes, Ms. Reeves, I walk past the mirror and I look at myself and I say, are you really doing the best you can today? Get some more strength and do this thing because you got to do it. Right? I was telling a friend of mine the other day, I said, oh, this season that I'm in, where it seemed like it's the season of what I call the season of help, where I'm having to help a lot of different people for a lot of different things, people who are sick, people who are, and I'm saying, their situation, I was talking to another friend of mine and they asked me how I was. They said, how you doing? And I said, sis, I'm exhausted. I said, I am completely exhausted. I said, but you know what? I'm thankful in this moment that I am the person giving the help as opposed to the person needing the help, right? So as exhausted as I've been, that's how I have come to look at that, right? And then I was like, I was trying to save towards something and, we're only in January and I've had to kind of give it up because there's someone else that needed it more than me. What I'm saying to you is in this moment, you're the person that kind of needs the help. It sounds like to me. But even in that, you're going to have to look at you're going to have to try to find the good in that. And you also, because of this case, there's not a time, Ms. Reeves, hear me closely. Because I want you to get your daughter back so bad. I don't want you to get evicted. I want to refer you to somebody to help you make sure you don't get evicted. Like, I don't want those things for you. But let me say this to you. Me not wanting it for you, you got to not want it for yourself. And there's nothing that's going to make you drink. You need to find another go-to. Whatever reason you drank on Christmas, you cannot. And I understand too that the case was a long time ago or a few years ago, whatever. But while you're on probation, you can't drink. So you just gotta suck it up and be an adult about it. Whatever they're celebrating. There was a time when I used to go out to socialize after work because they tell you, you're supposed to be sociable. I'm not necessarily a sociable, I'm an extroverted introvert, they tell me. When I go out, I might be the life of the party. but I'm sure ready to come home as soon as I get there. But I used to go out after work to be sociable. And everybody on my job knew when the bartender came over, we used to go to this place and get chicken wings and something. This was after work. And the bartender would come over and say, around the drinks, or would you all like something to drink? And the people would order for me. They would say, well, she want a Diet Coke with a lemon twist. Because that's what I was. That's the season I was in. Number one, I'm unveiling myself to be the designated driver to somebody because y'all out here drinking. And I'm never going to put my license on the line for a drink. So, and you know, so that what I'm saying to you is between now and the end of your probation, whatever y'all doing, you're going to be the designated something. You're the person who's not drinking on that occasion. Because this is my position and opinion, Ms. Reeves, whether you agree or people agree or not. I cannot want for you more than you want for yourself. I'm rooting for you and your daughter, but you got to root for you and your daughter, which means you can't drink. Okay?
Yes.
So I'm going to write on my paper that you cried and that I was moved. Because then that's going to remind me, if you cry next time, I'm going to be like, Ms. Reeves, you cried last time.
I assure you, these is not fake tears.
Okay. All right. So I'm going to take you back down. Let me finish writing my note. Okay, so I'm gonna take you back down. No more once a week. I just put you on probation. Is this your first review? Let's see. No, I put you on in June. So you already coming up on the year. However, because I don't want you to be stressed out and things and such. As long as you are making a great effort towards your probation, I'm not gonna I have up to 2 years with you. Now, I don't want you to be on probation for 2 years, but I can keep you on probation for 2 years. So if we get up to the 1 year mark and you still can't make it happen, but as long as you're not drinking, so on a drunk driving case, you not drinking is the most important thing that's going on here. Okay. So as long as you're not drinking, we can extend you. We can extend you once you get your housing situation set. We can, if you want to do some community service to offset the balance, we can do that. But I'm going to give you a review in 3 months to see how you're doing. I'm going to keep your testing where it is, but you cannot drink, Ms. Reeves. You cannot. Okay?
I won't. Thank you so much.
You're so welcome. How old is your daughter?
My daughter is 7. Her name is Aubrey.
That's pretty. I have a
Thank you.
friend who has a granddaughter named Aubrey.
She looks just like me. She's just light skinned.
She do. She look just like you. That means she's so pretty.
Thank you.
All right. So let's see. I said 3 months. 1, 2, 3. That puts us toward the end of April. Let's see. April 25th at 1:30. So forget the March 7th date. April 25th at 1:30. But you crying today, okay? All right, let's make it happen.
In April, because it's gonna be paid as soon as my taxes come.
All right. Can I crack a joke? Do you mind if I crack a joke?
Go ahead.
I saw a Facebook post. It was either Facebook or Instagram. And it said, this is the season of I'm going to pay you with my taxes come.
A lot of people. Oh, I'm not gonna lie.
So don't worry about it.
So you said 20, you said April 25th at
1:30, yes, at 1:30.
1:30. Okay, thank you.
All right. Good luck to you, Ms. Reeves.
Thank you. Have a good day.
All right, you too.
Thank you, Your Honor. Thank
You're
you.
welcome.